Imagine this. Your family wants to grow, but you're facing a medical hurdle. Should the law get to have the final say? Today, we're diving into a really personal issue that's turned into a major legal fight in India: the right to have a second child through surrogacy. Let's get right into it.
Okay, so at the very heart of this debate is a condition you might not have heard of. It's called secondary infertility. Basically, it's when a couple has already had a child but then finds they can't have another one. And the causes can be the same things you see in primary infertility, like PCOS or endometriosis. It's a really frustrating and, honestly, heartbreaking diagnosis for a lot of people.
And that brings us right to the core of this whole thing. Just put yourself in that situation for a second. You want to complete your family, the medical tech is there to help, but a law is standing in your way. And this isn't just some hypothetical. It's the real story of a couple who took their case all the way to India's Supreme Court.
So what is this legal barrier we're talking about? Well, it's a key part of a pretty recent law, the Surrogacy Regulation Act of 2021. And while this law was meant to regulate the whole surrogacy process, one of its rules has created this massive hurdle for some families.
And the rule is super explicit. Section 4 of the Act says a couple is only eligible for surrogacy if they have no surviving child. It doesn't matter if that child is biological, adopted, or from a past surrogacy. The law just doesn't make a distinction between wanting a first kid and wanting a second. If you already have one, that door is pretty much closed.
Now you might be thinking, there must be exceptions, right? Well, yes, but they are incredibly narrow. The law only makes an exception if the couple's existing child has a severe disability or life-threatening illness. For any other reason, including the diagnosis of secondary infertility, that ban holds firm. So as you can imagine, a strict rule like this was bound to lead to a showdown in the Supreme Court. And it's a classic conflict, really. It pits an individual's right to make these deeply personal life choices against the state's power to regulate social practices. So let's break down the two sides of this debate. On one side, the petitioners are saying, look, the state has no business getting involved in our reproductive choices. They believe it's protected under the right to privacy and that infertility is infertility, whether it's your first child or your second. But on the other side, the government says surrogacy isn't a fundamental right, and they argue that the state needs to have these rules to protect women from being exploited and to stop the whole process from becoming commercialized.
Now, during the hearings, there was this interesting moment. A judge actually remarked, just orally, that the restriction, the ban on surrogacy for a second child, seemed reasonable. For a minute there, it really looked like the court might just side with the government's strict take on the law. But that wasn't the end of the story. Despite that one comment, the court decided to take on a much bigger, much more fundamental constitutional question. They agreed to formally examine whether this law actually infringes on the reproductive autonomy of citizens. And just like that, a single family's plea was elevated into this huge national debate about our rights.
And this opens up a whole new conversation, right? If the law is too restrictive, what's the solution? Is there a way we can reform the act to find a better balance between, regulation and personal freedom?
I think to be fair, we have to remember why this law was even passed. The main goal was to shut down the commercial surrogacy industry, which, let's be honest, was often exploitative. It was meant to protect the health and rights of surrogate mothers, and that was a necessary reform. The real question now is whether banning a second child actually helps achieve that specific goal.
So the key to a solution might not be to just scrap the whole law. Instead, it might be to reinterpret it. Legal experts are suggesting a more expansive interpretation. Basically, one that respects the law's original intent, but is also more compassionate to what families with secondary infertility are actually going through.
So, this path forward seems pretty clear. First, you keep the ban on commercial surrogacy. That's not up for debate. Second, you get rid of this kind of arbitrary line between primary and secondary infertility. If there's a medical need, there's a medical need, period. This would let all couples who have a proven medical need use altruistic surrogacy. That's where the surrogate isn't paid beyond expenses. It seems like a way to balance the rights of parents with strong protections for surrogates.
So ultimately, the goal is to have a law that can do both things at once. A system that can actually help people build their families using modern medicine while making sure the whole process is ethical, altruistic, and totally free from the exploitation that we saw in the old system. You see, these two goals don't have to be at odds with each other.
And that leaves us with a question that goes so much further than just this one case. For any society, how do we write laws that protect the most vulnerable among us, but without putting these unreasonable limits on our personal freedom and our choices? It's that delicate balance that lawmakers, courts, and all of us as citizens are constantly trying to find.